Any mention?
That's it.
Yes.
To mention item number 26.
Why?
Lordship, I supposed to get the
Where's the
record.
petitioner?
Petitioner, I inform you. Lordship.
No, where's the petitioner now?
Maybe I should have outside. I already made.
Which item?
26.
I'm here, Lordship. Lordship,
Yes.
the Court of Inquiry records are required in this matter.
You haven't got records. When was the court's call last?
Last, it is
When?
last
When?
3 weeks.
Last year.
Last 3 weeks.
Sure, I can find. Some matters just lying like this. 26.
(17/4), Lordship. 17/4/24.
When you produce the records? Who's the officer responsible to who has custodian of the records?
Actually, it will come from Manipur. Lordship.
You can't take now we're sitting in June. We can't have an order of this court passed in 17/4. Till now I can't produce the records. We can't hear about the records.
Lordship, it's necessary because the marriage certificate.
I think we'll ask the officer to come here with the records. When can he come? He can come on Monday with the records.
It comes from 2 weeks. Lordship.
No, he can come on Monday. He has to come personally. Now, why the records? When did you seek the records from the concerned officer? When?
Last week again I given.
No, when the first time, after 17/4, when is the first time you asked for the records?
Immediately after this order, thus we are giving the requisition.
You produce a letter, we'll list it on Monday. Otherwise, we can't have this kind of produce records, you wait, we can't wait forever. You produce the letter on Monday, and we pass orders. But with the concerned officer, he has to come and produce the records. On the prayer of Mr. Adebnath for production of records, this is case on Monday for necessary orders, yes. You produce the letter you send.
May I please, the Lordship. My Lord, item number 30, 34 and 35, my Lord. 30 is, my Lord, we are challenging that termination, my Lord, the permanent proceeding. So we need some more time to do some research. 30 of the hearing list, my Lord. 30. Madam Yangi is on the other side.
She's indisposed, Your Lordship.
So can we play for
No, 30?
30, 34 and 35, my Lord. 34 and 35 is against Nehu, my Lord.
Where's Nehu?
Mr. Sen has
30,
yet
okay,
to
30 after
2 weeks, my Lord. And this 34 and 35 after 1 week only.
where's the other side?
My Lord, Mr. Sen was not here, my Lord. I could not mention.
The other mention, you know,
No, I have not informed him, but his junior is there, my Lord. I have informed her.
1 week, yes.
1 week.
34 and
Yeah, 34 and 35. Yes, my Lord. Hi, Lord, your place.
May I please, Your Lordship?
yes. Yeah,
So I beg to mention item number 33 of the daily list, my Lord.
yes.
My Lord, in this matter, my Lord, we have been led by Dr. Shraf. Now, Dr. Shraf is out of station on some personal occasion, my Lord. My Lord, we can adjourn the matter for today and fix it after 2 weeks, my Lord.
Okay, list the matter after 3 weeks, yes. Yes.
My Lord, the matter pertains to transport subsidy, my Lord. The
Yes,
pleadings
yes.
are complete.
Yes. 3 weeks, yes.
May please, Lordship, I beg to mention item 27.
Number?
27. Lordship, I prefer 2 weeks' time, Your
Where's
Lordship.
Mr. Gautam?
Your Lordship, he has a matter in DB, Your Lordship.
22 matter. As the whole hearing just gets disseminated. Why need adjournment? Just because your matter in DB?
No, Your
DB will
Lordship.
get over soon.
The other
They'll
counsel,
come
Your
up
Lordship,
with
is handling this matter. Miss R. Kharshing is handling this matter, Your
Who is
Lordship.
the Khashi?
My colleague, Your Lordship. She has some personal difficulty, Your Lordship, for today.
Yeah, 1 week, yes. Otherwise,
Obliged, Lordship.
Obliged.
Yes.
May I please, Lordship? Your Lordship, I beg to mention item number 20.
Where's Mr. Qureshi? Who's the other side?
Your Lordship, he is on sanction leave.
And for the respondent numbers.
Yes. No objection?
No objection.
Okay, 2 weeks, yes.
Highly obliged.
Lordship, I beg to mention item 23.
23. Why?
Lordship, if this matter may kindly be taken up after 2 weeks.
What's the matter about?
This matters regarding the eligibility of clans to be elected as aim of Malay Sokmat.
EM of
Malay Sokmat.
Oh, no objection.
1 week, 2 weeks.
2 weeks, Lordship.
Yes.
Lordship, I pray a similar prayer for item 38 and 39 also. They're connected matters. If you can kindly accommodate for 2 weeks as well. 39? 38 and 39.
What's the matter about 38, 39?
Regarding regularization.
Do it for the petitioner on 39. You have no objection? Okay, 1 week, 22 matters.
2 weeks, Lordship.
Why?
Kindly. We need some time in preparing the matter.
Okay, 2 weeks, yes.
Obliged.
Yes.
Your Lordship, I beg to mention item 31 on behalf of Mr. A. Kharwanlang. He's indisposed. He's for respondent to...
No objection, Your Lordship.
2 weeks, yes. What
Obliged,
happened to him? He's in hospital.
Lordship, right now he's resting at home. Obliged, Lordship.
May I please, Your Lordship? Your Lordship, I beg to mention item number 28, Your Lordship. If this matter could come up after 2 weeks, Your Lordship.
Lordship,
Any objections?
have objection, Lordship, 2 weeks.
Yes.
The matter come
Get
after.
ready to matter. He's ready to argue it today.
Lordship, this matter, there is an interim, Lordship, that's why, Lordship. So,
It'll come after 2 weeks,
they've
Lordship.
informed us today morning, so I'm praying if this matter can come next week, Lordship.
After
Because there's
2
an
weeks, Your
interim
Lordship,
order
because
in the
the
field.
conducting council
Do it
is...
today, yeah?
No, sir, Your Lordship, the conduct council is it have some personal difficulties, Your Lordship. So if this matter could come after 2 weeks, Your Lordship.
1 week, Lordship.
Okay, no mention been made for seeking adjourn for 2 weeks on objection to Mr. Tidahar, who submits that interim orders operating against him. This is matter after 1 week, yes.
Deeply obliged.
Much obliged, Your Lordship.
Yeah, please, Your Lordship. Your Lordship, I beg to mention item number 21 on behalf of Mr. A.H. Hazarika. He is not
20?
available. 21, Your Lordship. For the state respondent. He is not available today, Your Lordship.
Where's the petitioner? Have you informed petitioner?
No, Your Lordship.
Then let it be called out, yes.
Obliged, Lordship.
You don't inform the petitioner, don't mention.
Your Lordship, they were not
Yes.
available.
Let it be
Wait,
called
please,
out.
Your Lordship. Lordship, I beg to make a mention of item number 18.
Number?
18 and 19 are connected, Your Lordship. 18 and 19. I pray for some accommodation in this matter, Your Lordship. As the learned DSGI is not keeping well, Your Lordship.
It's for disposal today, correct? He's not keeping well.
Yes, Your Lordship.
Okay, after 1 week, yes.
Similar prayer for item number 24.
Who's that? Yes, we,
Similar prayer for item number 24 and 25, Your Lordship.
18, my lord.
okay, Mr. Kumar, DGSI is not well. After
My
1
lord.
week, yes.
24 and
My lord,
25,
my
Your
lord.
Lordship, connected.
My lord.
24 and 25.
Who's for the petitioner? Mr. Pathak. 24,
My lord,
25,
I
Mr.
am for the
Kumar.
petition in 24. My lord, 2 weeks, my lord.
2 weeks, okay, 2 weeks, yes. Yes.
Highly obliged, Your Lordship.
My lord. Declare it.
Please, Your Lordship. Your Lordship, I beg to mention item number 22 on behalf of S. Dota. Let this matter
Become
come
sad
after 2
story.
weeks.
Just,
He said
you have objections?
No objection, Your Lordship. It's not present.
After 6 weeks.
2 weeks, Your Lordship.
Take more time in to prepare for your senior. Who are you representing as Data?
Yes, Your Lordship. He said due to water logging today, he could not reach him.
Okay, 2 weeks, yes.
Highly obliged.
I don't really sort of.
Supplementary list, item number 1.
Yes.
May I please, Your Lordship? Your Lordship, this matter pertains to the non-issuance of the pass certificates and correct mark sheets, Your
Pass
Lordship.
certificate from where?
Of DLED course, Your Lordship. DLED course, Your Lordship.
By whom?
By the respondent NIOS, Your Lordship.
By the respondent.
NIOS.
Number?
Respondent number 2, 1 and 2, Your Lordship.
National Institute Open Schooling.
Your Lordship.
The notice will have to go.
Your Lordship.
Yes, I accept notice on behalf of respondent number 3, 4 and 5.
MSP Biswakarma, Learned Counsel for the petitioner, issue notice. Mr. H. Kharmi, Additional Senior Advocate,
Yes,
is present except on behalf of respondent number
3, 4 and 5.
3, 4 and 5. So no further notice required on these respondents. Petitioner takes steps within 3 days for issuance of notice on respondents from 1 and 2. This after 3 weeks. Yes.
Highly obliged, Your Lordship.
Item number 2.
May I please, my lord?
Yes.
My lord, that market has developed in Rinku A village, which has been called Rinku Bazaar village now. Now the chief of the Sardarship, now there is an acting Sardar. The acting Sardar along with one Mantri, they have issued a toll list for the articles brought to the market by villagers, their home products or anything. And from the market also, there are few shops developed there during course of time. But this is not a market as per the 1979 regulation. So this market has grown in violence of the Khasi Hills Autonomous District Establishment, Management and Control of Markets Regulation 1979, Section 5, Section 10, 11 and 12. In violation of these sections, this market has grown up. And for this market, recently the acting Sardar and a Mantri together they have issued a list that is Annexure 6 on page 22, my lord. Now this list, the villagers are unhappy. Earlier days, the tolls were very nominal, like 10 paisa, 20 paisa, like that. Now they have raised it and there is no approval of the district council.
Where is that? Where is that told?
Page 22, my lord. The type page is also given next. And this is not an approved list by the executive committee of the district councils according to law.
For per kilo?
Yes, my
Whoever
lord.
brings fish, 20 rupees.
20 rupees. Earlier it used to be 20 paise, 30 paise, like that.
Now eggs 10 rupees per box. Have you made this a council party?
Yes, my lord.
Who's appearing? Is it council who's appearing? No one appearing?
No one has appeared so far.
Who's appearing to the council? You served him notice?
This we have served to government actually. I have not served. I will serve to district council and the private respondents.
Mr. P.K. Vora issued notice.
Yes, ma'am.
It is submitted that notice only been served to number 1. Petition to take steps to serve the standing council of the district council. Name respond number 2. List next week. Yes. Let them. You first notice, then we'll see.
Obliged.
Item number 3.
May it please, Your Lordship.
My lord, bring this matter will be taken up at the end of the board, my lord.
Where?
End of the board, my lord.
Monday.
End of the board, my lord. He's on his legs.
May I have it Monday, my lord, because I have a matter before division bench, my lord.
There is this interim prayer, my lord. My lord, may
Where's Mr. Paul?
He's on his legs, my lord, in division bench, my lord.
Let's wait for some time. If it doesn't come within, then
Item number 4.
yes, Mr. Sen.
Please, Your Lordship. Lordship, the petitioner was suspended.
No, yes, we know that.
Lordship, my
Your
kindly-
only contention is that 90 days, correct?
90 days.
And then they have not considered a review board within 90 days.
Within 90 days.
But when did you inform? The only date, did you inform them within the...
On 18-1. Lordship, kindly come to my... I filed my rejoinder, Lordship.
Let's see your rejoinder. Otherwise, I will reply 9/18. Yes, okay.
Lordship, I filed it on
Yes,
14 June, Lordship.
Okay.
Lordship, para 5. Lordship. Now I've set out the sequence of events in the table, Lordship. Then next para. Lordship, if I may allow to. Now the petitioner was taken to custody by police on 1911. Now, petitioner was placed under suspension on 1911, the same day. Now petitioner was granted bail, interim bail, from 8/12/2023 to 20/12/2023. Now he was granted final bail on 20th December 2023.
Yes.
So now, Lordship, the 90 days period of suspension expired on 18/2/2024. Now, Lordship, now the respondent has directed the petitioner to supply the bail order on 10/1/2024. Now he has replied that on 18/1/2024. He supplied the bail orders. Now, as per the affidavit, Lordship, filed by the respondents, the review committee was constituted on 28/3/2024. Now, the 90 days period expired even after submission of the documents to NEHU is 17/4, Lordship.
How do you say this? When
From
you
the 90
supplied,
days.
You supplied your bail
supplied on
order only
18.
in 10/1 information
On
to
18.
the 18/1, right?
Counting from that date, Lordship, the 90s, counting from the date of intimation of the bail orders, the 90 days expired on 17/4/2024.
Yes, but they constituted on 28/3.
Lordship, kindly come to the rules, Lordship. Lordship, the next para, Lordship. From a conjoined reading of Rules 10 and 10.7 of the Rules 1965, the deponent will submit as follows. That for the purpose of Rule 10.6 and 10.7, the relevant date is the effective date of suspension, which in the instant case was 19/11/23, and the period of 90 days expired on 18/2/2022, on which the date the deponent was already granted bail. Now, number C, Lordship. That on 10/1/2024, NEHU authorities asked the deponent to submit the court orders to enable the university peruse and examine. So pursuant to the above, the deponent submitted the court orders, and as such, the NEHU authorities were well aware even on the date on 18/1/2024. Now, that number D, that even assuming that the NEHU authorities came to know, were informed about the grant of bail, so the 90 days period expired on 17/4/2024. Now, E, Lordship, that as stated in the affidavit in opposition, the purported review committee recommended for continuations of suspension on 4/5/2024. Lordship, for further clarification, Lordship, kindly see the rules, Lordship. I may be allowed to read the rules, Lordship.
No, your only contention is that
Lordship,
notwithstanding constitutional review committee, effective orders must be passed in 90 days.
Lordship,
The whole crux hinges on that.
What I'm saying is that, Lordship, there was only a recommendation by the review committee. Now that recommendation has to culminate into an order passed by the competent authority.
Now what you're submitting is that if there is 90 days will mean that within that period of 90 days there must be an effective order.
Lordship.
Whether to continue suspension or to stop
To
it.
revoke, Lordship. Lordship.
Yes. So your contention is that though the review committee was constituted on 28th,
On 28th.
no effective orders were passed.
No orders.
And orders for continuance of suspension was passed only after the 90 days had elapsed.
No, Lordship, there's no order of because
There's no order of continuance also.
There's no order, Lordship. That is indicated in their affidavit as well. Lordship, kindly come to page 5.
What happened in 17/4?
Lordship, 17/4 is, Lordship, if we count from the date of intimation of the bail orders.
Okay, they said 4/5/24. Where's the
4/5 is only the recommendation. Kindly come to page 5 of the affidavit filed by the respondents.
Yes.
Page 5, Lordship, of the affidavit filed by the respondents.
Page
Para 8,
5.
Lordship. Para 8.
Yes.
Now, with regard to the statements made in paragraph so-and-so, the deponent reiterates that the committee was duly constituted on 28/3/2024 for the purpose to review the suspension of the petitioner. As stated earlier, the allegation and so-and-so. Can below, Lordship.
1 second, let lights come on. Yes.
It may be stated here that the committee constituted to review the suspension was well within the stipulated time as provided in Rule 10, 6 and 7 of the CCA Rules 1965. However, the ultimate recommendation made by the said committee was on 4/5/2024. However, considering the pendency of the instant case, University has not initiated any further action with regard to the recommendation made pertaining to the suspension of the repetitioner. Now, kindly come to Rule 10.6, Your Lordship, which is
Yes.
page 33 of the writ petition. The last page, Your Lordship. Rule 10.6, Your Lordship, I may allow to read.
Yes.
An order of suspension made or deemed to have been made under this rule shall be reviewed by the authority which is competent to modify or revoke the suspension before expiry of 90 days from the effective date of suspension on the recommendation of the review committee constituted for the purpose and pass orders either extending or revoking the suspension. Subsequent reviews shall be made before expiry of the extended period of suspension. Now, sub-rule 7, Lordship. An order of suspension made or deemed to have been made under sub-rule 1 or 2 of this rule shall not be valid after a period of 90 days unless it is extended after review for a further period before expiry of 90 days. So, the recommendation was only, the 4/5 was only a recommendation. It's not an order passed by the competent authority as required under 10.6.
Where's that 4/5 order? Let's see.
They have not annexed the recommendation as well, Lordship.
Where's the recommendation, Mr.
They're not annexed.
Sen? Let us see what it says.
This is a recommendation. Recommendation.
Let us see why you haven't annexed.
No,
it.
we have money. We have recommendation.
My contention is that the recommendation has to communicate into an order which is passed by the competent authority.
You brought the records?
Sorry, my lord, I have the constitution of the committee. Sorry, my lord, I can place that record. Constitution
So
of
what was the order passed on 4/5? That's
For 4/5, there was a recommendation. My lord,
Where's the
need
recommendation?
to be.
Why it was not annexed to your
My lord,
affidavit?
I'll place the records, my lord. It is there. Because here, what I have
Lordship.
received, my lord, I have received the constitution, my lord. Constitution of the committee on
See,
28
understand
March.
this case. He says that notwithstanding any constitution, unless effective orders are passed, then the suspension will lapse.
My lord, only thing, my lord, I'll just point out. Just bear with me, your lordships. Now, these man, my lord, he is charged with section 376. The
Doesn't matter, he's come
incident,
on
my
a
lord,
technicality.
took place, my lord, within the premises of the university, my lord. He was arrested, my lord. Lordship is now fully aware, my lord. Arrest is normally not made like this, your lordship. After some inquiry, after some good evidence, my lord, he was detained, your lordships. Now, my lord, he was placed under deemed suspension. It's true, my lord. Now, my lord, the ICC is not even a party. ICC has seized upon the matter. Lordship is fully aware, my lord. These kind of things are taken up by the ICC. Now, any departmental proceeding or other thing for the university, that will depend on the recommendation made by the ICC. Now, ICC yet to make any recommendation, your lordships. Now, man, my lord, with these kind of allegations, my lord, only on technicalities, if we restore him, my lord can understand, my lord. One thing, my lord, tampering with evidence, other things, my lord, the kind of repercussion it will have. So, my lord, so my humble submission, my lord, so far what my learned friend is saying, your
You
lordship.
produce at 4/5, we'll pass orders. It's on Monday.
My lord, only thing, your lordship, so far constitution is concerned, my lord, that was done within the time.
The records.
Within the time. Record I'll please, your
Produce
lordship.
the records according to order. If his case is that, then that 4/5 order, there was no effective 4/5 sitting of
There
the
was a
committee.
recommendation.
There
There was
no
a
effective
recommendation.
order.
Anyway, I'll place that before my lord.
Yes, it appears that it was some affidavit that the what orders 4/5? Where is that? It appears from the affidavit filed by respondents 1 and 2 that the recommendation of the committee, review committee for the suspension of the petitioner, which had sat on 4/5/2024, is not available. Learned counsel for the university to produce the same on the next date, along with other relevant records.
Even the recommendation is beyond the 90 days period.
Doesn't matter. Why arguing the case? Let's see the records.
Obliged.
Just on Tuesday, better. Give you enough time. Tuesday.
Okay, sure.
Daily list item number 1.
Please, Lordship. This is the Akang matter, Your Lordship.
Yes.
Since this Akang, Your Lordship, was the separate Akang was existent since from 1926, Your Lord. My Lord. Then there was a Majumdar report separately. The Majumdar has clearly demarcated that saying that the mark
only one
A,
ground you have to satisfy, if you remember, why it's been put for, if I correctly remember, is that this case is hit by the adjudicator.
So,
It's all decided case. You only have to satisfy the court that it was not decided. That's all.
Your Lordship,
That this issue remains open.
Yes.
Then we'll issue notice by respondents, the other Nokma.
Yes, Lordship, may I take you to the page 48.
Page
48.
If we can satisfy the court
Yes,
that this is the
because
earlier order past 1926, 26, correct?
There was no such clear order, and that was not an issue before the court of EM.
Where?
The page 48 is the order where the crack of the case, where the case started. Actually, the case was settled since long back. Why it is come up? It is reflect here, Your Lordship. May I just this is the type copy.
Page 48.
48. This is the order of the EM. Because here everything, the entire history is narrated, my lord.
This is in your favor?
Not in the favor, but I'll
Okay,
just
see,
yes. May I just read, Your Lordship? Since the petition filed regarding the Akang dispute between the Jelbongpara Akang land and the Akang Sikagri Akang land, pursued the old record and found that the petitioner is the defendant, moved relatives of Mona Marak and his wife led Mangi Guri Sangma and the Akang Nokma of Sikagri Akang. Pursue the case, it is...
Slowly.
Yes,
Lordship. To go somewhere?
No.
Slowly.
Okay, Lordship. Pursue the case. Long since the British rule. Since from British rule. And the case started between Sikagri Akang Nokma led by Baljarang Nokma. The case ultimately decided by the Panchayat dividing the dispute land to led Mona Marak of Sikagri and led Baljarang Nokma of Jelbongpara. As per the decision of the Panchayat, the disputed land in question mark A to led Mona Marak of Sikagri and his way, and this way Sikagri Akang was created. The mark B and C belongs to Jelbongpara Akang of led Baljarang Nokma. The Majumdar have submitted the report on 13/05/1926. Along with the Panchayat decision, drew up a map, also drew up GT of led Mona Marak Nokma of Sikagri Akang on 12/5/1925 and submitted the report in the same way, in the same day. It has been found but later that when Jelbongpara Akang map was redrawn, the portion of land mark A, which was given to led Mona Marak of Sikagri, also merged with the disputed land mark B and completely tagged with Jelbongpara Akang was marked C. The newly created Sikagri Akang, according to the Majumdar report dated on 13/5/1926, was completely upsurged and merged with Jelbongpara without any reason. And the Sikagri does not know, and no one took serious notice of the anomalies which crept in the preparation of the map of Jelbongpara Akang. When the notice about the preparation of Jelbongpara Akang map and played tricks upon the Sikagri Akang by unknown hand, after knowing that the petition filed for profile drawing of Sikagri Akang map on the basis of the Majumdar report dated 13/5/1926, because it is clearly denied the boundary mark A given to late Manu Nokma of Sikagri. The court again deputed the Majumdar to conduct the preliminary inquiry and submitted the report on 19/1/2006, stated that Manu Marak never give any blank written agreement not to make trouble. If such agreement is made on 21/5/1925, then it has no value, as the Panchayat decision was later made and distribution of disputed landmark A and B were effected on 13/5/1926. The alleged agreement never compromised led Manu Marak acquisition of landmark as mark A, as it appeared from the date of or alleged execution. The issue in this case is very old and berber evidence which have no value, by knowing that the Akeng Nokma of Jelbongpara, Akeng will not able to show any.
Now, what sum and substance of this order of this 22/12/2008? Correct. This is
Yes,
for the EM in charge revenue.
Yes, EM in
Now,
charge
he
revenue.
says that in 1926,
yes,
there was a decision by the
Panchayat.
Correct. There were 3 plots. So A, B, and C.
Yes.
So A was demarcated to belong to
Sikagri.
Sikagri, right?
B
Sikagri.
and yes.
And then B and C to Jalbangpara.
Lordship.
Correct.
Lordship.
Now you see later on somehow A, B, and C were usurped to become
Lordship.
Jalbangpara only.
Yes.
Okay. So that is where you Then what
And
happened?
then we
after?
filed. Then against this order,
Yes.
the private respondent they filed an appeal. Then the appeal was dismissed. Now, during the pendency of the appeal, the private respondent also have withdrawn their appeal, Lordship. May I take to the annexure 64? This is the judgment. Even it is reflected. Even I have enclosed the withdrawal petition filed by the private respondent, because when this case was, when the EM has passed this order, they have filed an appeal before the CEM. During the pendency of the case, the private respondent have withdrawn that case. And it is reflected. May I just take you to the page 64? Page 64.
This is the order of this court.
This is the order of the High Court.
Yes.
I will just read it. Here also it's just almost similar. They reflected. I will just read it, Your Lordship. I'll only.
Now, appeal was by the private respondents, correct?
Yes. Then they have withdrawn.
Where is that recorded in the order of the
Yes, it is here also. I will just read it. The page 65. The page is similar. It's a continuation of that only.
Yes.
Here it is. The relevant para 2 is just, it may be of vital importance that during the pendency of the above said appeal, the respondent number 4 filed an application dated 4/11/2009 through each serving Nokma seeking withdrawal of appeal, surprisingly, without taking the note of the explicit desire of the respondent number 4 to withdraw his appeal.
This you're reading the synopsis of the case. Is that a finding? I'm the order of this court.
This is the order.
It's not the order. This is just a reproduction of synopsis of the case filed by the at that point. What is the effective? What is the orders passed by this court regard to this matter? Where is that? In this order only show.
Yes.
How was the conclusion?
The conclusion in the conclusion they have after this order they have filed.
So where's the conclusion of this order? What does it say? Let's see.
Yes.
No, the consequence after submission, so.
Page 67, my lord, may I consider?
The daughter. So,
page 67.
So moto in nature.
Page 67. This stand disposed, and then after that they have filed a.
One second.
Lordship.
So, against this order dated 2008 order, there was a
review
23/8/2013.
Yes.
This passed by the CM, correct?
Yes.
Okay. So what happened?
After this, after the order of the High Court 26/05/2015, the opposite party has filed a review petition saying that they were not implicated in the case. That is Annexure 9. Annexure 9 of the order, review petition. The review was allowed, they were implicated, and the matter was remanded back to the JHADC.
Or you didn't make them parties?
In the repetition, it is alleged that they have not made a party to.
So the order 26/5/2015 was recalled.
Lordship.
So what happened?
Then after that, that matter was remanded to the page.
Oh, then everything goes consider matter afresh.
Go
So
to
what
the
happened in the fresh consideration? Now
Fresh-
you impugn a fresh consideration.
the fresh consideration. They are saying that
Page 73.
page 73.
Right.
Of the impugn
So
order.
this is the order you impugn with.
Lordship.
You agree with now?
Yes.
Okay. Right.
Now they're saying, which I have earlier in the, you have written that there was no agreement that in the order.
So what's wrong with this order now?
Yes, they're
What's wrong
saying
with this order? Why you agree with this order?
here in there saying that
Now you
there
come-
there was a
No, where, how you agree with, show from the order. What are the findings of this order of the CM which you agree with by way of come by this petition now?
because they're saying that, that there was a Majumdar report in the 1926. And that is the
where was
finality,
that
and that order we have not challenged.
Okay,
That
let's read the order, yes.
His Lordship, that this the last para,
No,
page
read the order,
74.
Read the order, okay.
Page 74. Third paragraph. May I read, Your Lordship?
1 second. Okay. Yes, now you see, you've seen the order. Now you have to satisfy the court that when in 1925, correct, listen very carefully. When the demarcation was done, and this Monge Marak, Mona Marak, whatever, at a point of time relinquished and the map was redrawn. Correct? Showing that these lands belong to Jebong Para. Against that order, which was entered in the GT law, there was never any appeal. Was there any appeal at that point of time?
No,
by
Your
Mona
Lordship,
Marak?
that agreement, what they're claiming, that even that
No, we cannot reopen that. Now the agreement, Panchayat sat and the GT records were made, correct? By and approved by the Deputy Commissioner at that point of time, 1926. Now, you might have been aggrieved at that time that maybe that portion A, they say belongs to Sakegre, should not have gone to Jebong Para, correct? But factually, what has happened is that there was no appeal against the order 1926 arrangement. And only in 2006, that is after many, many years, you sought to revive the claim. And the EM in charge revenue at a point of time, without properly going through the records, had allowed your case by the order 2008.
No, we are saying that there was a
The thing
Panchayat.
that now satisfy the court whether was any appeal filed against the 26 arrangement. Can you show from the record some petition anywhere that at a point of time there was which was missed by the chief executive member while deciding the matter?
Is even those the report which they are saying that which I am required to be challenged, that 2011-26, even that document was never was before the Court of EU, and we were not even aware of that.
That you're not aware of that? That's in the GT records. That we're not concerned about that. There was a decision 1926. Was it ever challenged? No.
Here it says that there was a Panchayat decision. That Panchayat decision, we are not aggrieved by the Panchayat decision because
then the remains that you have
yes,
no
because
grievance.
in the Panchayat decision, my lord, what happened? They stated the Panchayat, as per the Panchayat decision, the report, the map which marked as A belongs to Sikagri and B and C belongs to Jelbong Para. That's why, that is the reason why we have not challenged.
You read this one. See, read this page 74, 1, 2, 3, 4th paragraph. Read it. Read especially, I just read this part. The Deputy Commissioner also arranged a Panchayat to look into the matter of claim, and the Panchayat also arrived at the same finding the portion marks A and B in the map is the Aking of Banjang Sangma, Nokmao Jebong Para, and submitted the report dated 2/8/1926 Deputy Commissioner. Mozadar was also directed to prepare and erect boundary dips, and the Mozadar submitted his action report in 2011-1926. Deputy Commissioner gave time to appeal, and when there was no appeal, he approved Mozar's report dated 2011-96, later by order dated 21/3/1930. Deputy Commissioner N.E. Perry approved the GT Warang map, inclusive of the Iramak the Ave sketch map, Jelbong Para Aking. So what remains?
Actually, I was not aware of that this document.
Yes, my lord, even if my lord find that the order
we can't
of
reopen
1930 was wrong, that is not our challenge.
Might have been some wrong, but by the efflux of time.
And this petition is hit by Dore Sangma, my lord, where they are in para.
Must be somewhere. You might have a case, but that was in 1926 or 1930. Sorry.
Para 23 hits him very badly, my lord. Para 23 of Dore Sangma hits
what
him
does
very
it say?
badly. It says, my lord, I will just read out. Because of what has stated above, we are of the firm view that the principle of res judicata, which is found on equity, justice, and good conscience, has to apply to proceed the proceeding before the revenue member also. The Deputy Commissioner so and so. The principle, the gist of the paragraph is, principle of res judicata will not allow us to reopen the controversy relating to the Nokmashe after the death of so and so. So now it was in 1930, my lord, and he has never changed.
You might have a grievance. Maybe that report at time was wrong. Maybe you were deprived of them, but then it's too late in the day. Take down.
Lordship, I will just will withdraw it for some time. Because Lordship, I wanted to, because this document which yes reflected.
See, you cannot, even if the document reflects something wrong, 30 years now, saying 24. That's 94 years ago.
But what?
94 years ago.
But this was
94 years ago, Mr. Sangma.
This matter was never in issue before the High Court
exactly
also.
94 years ago.
No.
The impugn order, you agree with an order which was passed 94 years ago. We appreciate your tenacity.
Your Lordship, but only thing is that because since there are another Mazunda report also that has to be appreciated because the same on the same year 1926, my lord.
We have heard you, yes. Yes, the petitioner who is stated to be the
Lordship, I will.
Who are you?
I am the secretary in Nokma actually. That's
Secretary Nokma?
No, that.
What position do you hold in your clan?
Who are the important the Tra of the.
You're a Tra, right? Okay. Where have you written you're a Tra?
In the flag of the case I have written.
Where have you written? You're a bona fide citizen, son of so and so, resident of so and so.
Para 6, if my lord consider para 6.
Okay.
Lordship, I will withdraw with liberty because there may be some. No, Your Lordship, because there is nothing wrong because if
nothing right also, Mr.
Now at this stage, no. My only question is it's a question of it's a matter of right because there may be because I have not gone through the document which actually Lordship. It is the fact whether we have not even verified what is the document, what it is the.
See, we're getting a very patient hearing. Now, the only thing that boils down is one thing: is an order of 1930, which sealed, which approved.
No, even
sealed order by Mozart report in 26. That's over.
No, Lordship, we are even questioning whether that there is a genuinity of that document. What is reflected in that document? We have not we have not seen also.
My lord, that this statement he is telling lie, my lord. My lord may kindly consider again. As per the annexure documents, old records in the appeal memo, he has definitely received the appeal memo. How he can make a statement?
Withdrawal will
not help him, my lord. Yes.
No, not necessary. But if so advised, then we'll file it. But maybe there is because at this juncture.
No liberty.
No, it is not necessary that we will be filing, but it is a right of business at least at this moment. I humbly report it. Maybe there is some other things also might. I will just get a clear instruction.
So he has filed half instruction.
No. I've got, but this document which is reflected in the order, they have never seen it because they said they have not access to that document.
Well, this matter has to be ended, my lord.
The Lordship is not ending because the Archival matter it is not a matter of. It is not a matter of.
When you move this motion, the court will not issue notice to private respondents, considering the nature of the case. Why should you harass them to come to this court?
Not harassing. Yes, because we are coming. Lordship, the principle of coming to the court is because when we have the doubt, we want to clarify just for interpretation of the.
Yes, take down. Yes.
I will just withdraw it with liberty.
I have a serious objection on the liberty, my lord. He will come back again and he will try his luck again, my lord.
No, if there is a case, why not? Same thing that can we dismiss it on the next date also? It can be dismiss it. It can be reflected. It can be reflected in the order.
During the course of hearing, after hearing the matter at length, and on perusal of the impugn order dated 7/3/2024, passed by the Chief Executive Member, Garville's Tolerance Council, Tura, it is noted by the court that the matter pertains to the genesis of the matter pertains to Mozdar's report dated 2011-1926 with regard to erection of boundary dips / marks between two arkings namely Sakegre and Jelbong Para Aking. Stop. It's further noted that this, in the impugned order, is recorded. It is further noted that Deputy Commissioner, after the said demarcation, had allowed time to appeal to other aggrieved parties, but as none was forthcoming, later White Order dated 21/3/1930, the Deputy Commissioner, one Mr. N. E. Perry, approved the map inclusive of the area marked A of the sketch map to be of Jalpang Para Aking. Stop. Next paragraph. The dispute sought to be raised by the present petitioner is that the said plot A was always a part of Sakalgiri Aking, and the same had been wrongly demarcated in the report dated 2011-1926. Stop. Next paragraph. Though Mr. P.T. Sangma has prayed that we allowed to withdraw the instant writ application with liberty to file afresh, in the considered view of the court, the same would serve no purpose, as what is being sought to be done by the petitioners herein is to revive a dispute which was closed as far back as in 1930. Next, for reasons aforementioned, the prayer for withdrawal is rejected and the petition stands dismissed. Yes, sorry. You have to put an end somewhere here.
Item number 2.
Where's affidavit? This is getting too much, Mr. Paul.
Well, insofar as this matter is concerned, I appear only for respondent number 3.
Exactly.
Now, my lords, there is no direction to respondent number 3 to act in terms of the order.
At least file an affidavit. File an affidavit. So
if your lordship just bear with me for 30 seconds, my lords, your lordships may kindly just have a look. What was the direction of the division bench? It's very specific. Now, why have I been made a party here, my lords?
Where's the direction division bench?
I'll take your lordships, my lords. It's an absolute abuse of the process of court. Your lordships will find that at page 15.
Page 15.
My lords. Paragraph 3.
Yes.
It is made clear that we have not gone into the merits of the matter, and in the event the appellant files representation as stated above, the same shall be decided by respondents number 1 and 3 independently. 1 and 3 are both the state. I was respondent number 4. That is apparent from the, my lords,
My lord, as far as
why have I been made a party?
MPS is concerned,
You
my
are
lord,
alleging violation was ordered in
my lord, they are the
22-10-21.
person.
My lords, they are saying that the division bench had directed them to file a representation. If filed, 1 and 3 is to
My lord,
consider and dispose
special
it of.
interview, my
They have
lord.
not disposed it of. My lords, why am I a party?
Interview has to be conducted by the MPSC, my lord.
That is not the grievance as my lords enumerated in this contempt petition.
No, we will hear it. It appears from the submissions of the United States Council that the respondent number 3 herein is not a necessary party. Because he may be struck off from the role of parties. It is less a matter for hearing. Yes.
Obliged.
Well, item 2 and 3 would be
similar.
Then why didn't your people are here appearing every time, seeking time?
Well, it's my apologies, my lords. They should have been
Give
brought.
them some, abdicate a bit of your authority also. Let them have some, you know.
It's the other way around now.
Fair play in the joints. Yes.
His Lordship. Your Lordship, there was an order for filing the rejoinder. Here, Lordship, I wanted to file an application to implead the personal secretary to government because there in the affidavit they have stated.
You secretary, correct?
Yes, I have not impleted this one. So I'll be filing within. Actually, I have prepared the application for
Very good.
this case.
Mr. P.D. Samas submits that though he is supposed to file the joinder on behalf of the petitioner, it is discovered that
personal secretary,
personal.
personal.
That it appears
Government
that
Meghalaya.
secretary of personnel is also necessary party. If he is allowed to
Yes.
bring on board an appropriate application,
Lordship.
just after 2 weeks.
Much obliged, Lordship. Item number 5.
Yes.
May it please your Lordship. Lordship, affidavit on behalf of respondent 1 to 3 is already filed.
Lordship, so far as the state respondents and the headman are concerned, they are just pro forma respondents. I pray for a week's time to file rejoinder.
She is appearing through VC.
You're for the petitioner?
Yes, Lordship.
What do you want?
Lordship, I pray for 1 week's time to file the rejoinder.
Okay, Ms. P. Agarwal, on behalf of the petitioner, please for the 1 week's time to join us.
Highly obliged, Lordship.
Item number 6.
My Lord, this is pertaining to an election petition where the condonation of delay was allowed, and I have challenged. In the meantime, what has happened, my Lord, the matter itself was dismissed. So the other side, my Lord, they have already filed a writ petition challenging that order.
Withdraw this one.
My Lord, this may be kept in abeyance till such.
If it's already been dismissed, of course, actions go on. What do you want? Why do you want to keep it pending?
That is what, my
Lord.
with a liberty, my Lord.
Yes, it's due to subsequent developments whereby the election petition filed respondent number 3 has since been dismissed. So he please allowed to withdraw this incident application or with liberty to file a fresh if so advised.
Obliged.
Accordingly, matter stands closed on withdrawal. However, liberty aspirate is.
Much obliged.
Yes.
May it please, Your
Contempt petition.
Lordship, this is a contempt, my Lord. Your Lordship, kindly see Your Lordship's order of 31st May. 31st May 2024, my Lord.
Yes.
Final opportunity to file the affidavit, my Lord. And the petitioner, my Lord, contemner has taken as many as 5 dates, my Lord.
No, my learned friend is objecting to me filing the affidavit, that's the substance of it.
Page
okay.
11, my Lord. Page 11. Lordship, kindly see page 11 of the petition, my Lord. Page 11 of the petition. Let me finish. Because this is a mockery which the contemner has made, my Lord. Mockery of the proceedings, my Lord.
No, my Lord, it's not been filed.
And your Lordship, this is a sheer gross case of contempt. This is a gross case of contempt, my Lord. He is occupying my property, he is not paying the rent, and he is disobeying the order. Kindly see page 11.
If my learned friend allows me to say something, I can probably say something.
Page 11, paragraph, my Lord, ultimately, the fate of the system.
I don't know what my learned friend wants at this stage.
Contemner like page 11, paragraph 4, my Lord. Third line, my Lord, Sri Mavin T. Marbangyang, who is personally present in the proceeding, claimant is unable to comply with the order. There is an order and he is not complying, and this was, my Lord, on 19th February.
Okay,
More than 6 months has happened.
Yes.
And your Lordship, kindly see Rule 6.2, my Lord. Rule 6, under which he has to answer the contempt, my Lord.
See, one thing, Mr. Amit Kumar, we will issue appropriate notices, initiating contempt. But let them, why have they filed affidavit?
Well, it's the two things why the affidavit,
Six days, my Lord. 6 days. 6 days. They will not file.
They'll pay cost, yes. Yes.
If my friend allows me to submit.
Yes.
Well, it's the two reasons why the affidavit's not been filed. One, my lords, this appears from this contempt application, as your lordships would have seen, it is for the purposes of recovery of some kind of money, my lords. There was some
This is a disobedience order. Disobedience is there.
Yes, yes.
May I finish, my lords?
Then file affidavit at least. Instead of...
My lords, the other aspect is a legal aspect. What has happened is, during currency of this entire proceedings, my lords, the term of the tribunal itself has come to an end. That my learned friend is also aware.
During
order
the
has not come to an end. Order has not come to an end.
Of that. If the matter has already been
because there is a fresh order passed by the tribunal, my lord, saying that if at all you want to extend that,
issue contempt direction. Will initiate contempt, otherwise you file affidavit subject.
Your lordships may have it on Monday, my lords. I'll file those.
Pay 3,000 cost.
My lords, what we'll do is I'm bringing both those two orders on record,
Mr. Paul. Otherwise, we can't allow the orders.
Because the fact of the matter remains. If I can finish, my lords, if there is interjection at this level, your lordships are already with him. I don't know what my learned friend wants.
Yes, Mr.
Because what do I do?
My lords, in a contempt application, can the directions be passed for paying? Your lordships are aware of the division bench order. Passed in a matter filed by my learned friend.
Yes, it appears that numerous dates have been taken, which have been allowed by this court for filing affidavit. On the last date, that is
14/6 minutes.
On 14/6.
31st May, 4th,
With one saying
14 June, my lord.
2024, an undertaking had been given by the Council for Expeditious that the affidavit be filed positively on Tuesday, the 18th of June 2024. Stop. Today, when the matter is taken up, the affidavit is still not on board. Stop. Mr. K. Paul Leonard, Senior Counsel, is also appearing for the respondent, prays that some accommodation be given, as there are other issues that have come up, which needs adjudication. Stop. Notwithstanding the prayer made by Leonard Senior Counsel, the filing the affidavit is closed, subject to payment of cost 3,000 rupees in favor of the Legal Service Authority.
Balance, may I pray it be in favor of the Shillong Bar Association?
Shillong, okay, Shillong Bar Association. Then make it 5,000.
Let it be 5,000.
Yes.
There I would not have any grievance.
Yes, 5,000 in favor of Shillong Bar Association. Stop, failing which appropriate contempt notice shall be issued to the respondent. List after 1 week.
That's
Amen.
nice.
Item number 8.
Please, Your Lordship. Lordship,
you taken steps?
I've taken steps.
Lordship, I am appearing for the short my lord.
Just for a limited prayer, my lord, for speedy disposal of the
Your
misapplication.
Lordship, my humble submission, Your Lordship, is coming here to stay the impugned
not stay, my lord.
order provision that was given, because it's like forcing the court to take a decision in the, because the prayer is that he's asking for injunction, because there is a three principle on the basis of rule where the court can grant the interim injunction. Number one, he has to.
What are you submitting?
He's saying.
What is your case?
My case is that, my lord, I have filed a misapplication, my lord. That misapplication has not been taken up. Only recently, my lord, the misapplication has been taken up. He's actually proceeding with the main case. We have filed it way back. Let's see, 4/4/2023, my lord, misapplication.
You filed injunction application since 4/4/2023.
Lordship.
And the matter has not been taken up once also.
It has been taken up only recently, my lord, last month only. But that is my prayer, my lord, before this honorable court, that at least the misapplication should be decided first, my lord.
Where is that?
That is at page 50, my lord.
Page 50?
Yes, annexure 8.
You're asking for stay of the probate?
Yes, my lord.
Miss case? Yes. Why hear the matter? If you have a good case,
That
then
is what,
you
my
won't
lord.
get a stay.
I'm not coming here for stay, my lord, just for
You'll be
speedy
appearing there
disposal.
also. When did you file it?
Filed it on 4th April 2023, my lord.
Stop. The petitioner, Mr. A.G. Movement Council petitioner, has submitted at the outset that the petitioners approached this court with a limited prayer only for directions for early disposal of miss case number 1 of 2023, pending before the court of the Learned Additional Judge District Council Court, Tura. Stop. He submits that the said application has been filed as far back as on
4th April 2023, my lord.
4/4/2023, and only recently on 14/3/24 has the same been taken up for consideration. He prays that as there is some urgency in the matter, that appropriate directions be issued for expeditious disposal of the same stuff. Mr. Next Prince P.T. Sangma, who has entered appearance today on behalf of the sole respondent.
Yes.
Submits that there is no urgency.
Yes, it's not urgency.
Submits that there is no urgency, and what the petitioner is seeking is to frustrate the probate proceedings.
Yes.
Already granted probate.
To them.
Yes.
They've all granted probate to them.
It's to frustrate the probate proceedings. Paragraph. Further, the counsel of the parties, notwithstanding the objection raised by the counsel for the respondent, considering the fact that the business application had been filed as far back as in April 2023, it is expected that the court of the additional judge, district sessions or district council court, GC Tura, take up the matter and dispose the matter as expeditiously as possible. We won't give time frame.
No, my lord, because the problem here in my lord, they are actually giving long days, my lord.
Yes,
that is
as if is possible.
Yes.
Preferably by giving short dates. Yes.
Watch.
Matters stand disposed of.
Item number 9.
Hello, my lord.
Parties also are to cooperate.
Hello, my lord.
Well, in this matter, my lord, we have sent for signing of the affidavit. If I can pray for 10 days' time, my lord.
For 2 weeks' time, as prayed allowed for affidavit by the respondents less thereafter and so on.
Item number 10.
10 is out.
My lords have granted us some time to examine the affidavit. Lords, I'm praying for some time to file a rejoinder. We've applied for copies of the orders passed by this court. My lords, there was certain litigation pending before this court. Certain directions were passed. My lords, where we were not party, so that's taking some time.
For 3 weeks' time, as prayed allowed to the petitioners to file rejoinder, yes.
Right. My lords, the interim orders may kindly be.
Interim
On the last occasion, there was no prayer for extension of.
Understood, my lord.
It's a.
11.
Much obliged.
Your Lordship, the affidavit of respondent 5 and 6 is still awaited. We've recently received the affidavit filed by the NEHU.
5 and 6 is whom?
5 and 6 is the member of the selection committee and the selected candidate.
Have you filed affidavit?
Lordship, I appear for 5.
Who's 5?
5 is the member of the selection committee. She was the member of the selection committee. Now the only ground alleged by the petitioner is that she's not an ST candidate. She does not belong to an ST.
You are a selected candidate. You are number 6.
I'm one of the member of the selection committee. And the rules provide that ST member should be present.
Yes.
Now the allegation is that I'm not ST. Now that has been clarified by the NEHU.
You are ST.
I'm ST, Lordship. And that has been clarified by the NEHU.
No, let them reply. You file affidavit then. You need to file affidavit.
Lordship, what happened is the...
What do you want to say? You want to file affidavit or not? Yes or no?
Lordship, that ground has been taken by the NEHU authorities because I'm
So
appointed.
you would not
by-
necessary to file affidavit.
If advised, I'll file, Lordship.
You can't ask the court to make a choice for you whether you want to file affidavit or not.
What I'm trying to say is that because the...
I don't know what you're trying to say. Court doesn't know what you're
I'm
trying to
appointed by
say. Say
the-
that fine.
I'll
You
file
don't
it.
make submissions on merits. If you need to file affidavit, say yes.
file it.
You don't need, you won't file.
I will file it.
You rely on the affidavit filed by NEHU. Affidavit behalf of respondents 1 to 4 has since been filed. Mr. Nongpur for respondent number 5 and MS. You also will file for 6. Pray and allow 2 weeks and file affidavit list thereafter.
Lordship, I'm appearing for respondent 7. I've
No
already filed affidavit.
12.
Lordship, affidavit on behalf of respondent 8 to 10 is filed.
What about 1 to 7?
As I have submitted in one of the occasion that the process for payment of land compensation is undergoing, my lord. And as per our list, my lord, there are 2 petitioners in the writ petition. Both the names are there, my lord, as rightful landowners. So the only delay, in particularly with these 2 petitioners, was there was a recalculation of the amount. So, my lord, we will be able to.
Okay, you have written instructions. We can dispose it of.
Instruction, my lord.
What is your stand? You just show them a copy also. Mr. Deb, you got a copy?
No, my lord, I have just received last evening, my lord. My lord, may kindly have the last 2 pages, my lord. The table, my lord, table number 29. That is petition number 1, my lord. The last 2 pages, the second last page, my lord. My lord, have it. My lord, my lord, my lord, that is petition number 1. And the second page, my lord, table number 32, my lord.
Vinash Marak.
Vinash Marak. The only thing is that, my lord, the name, my lord, spelling. So if it's the same person, because here we have B, with Vinash Marak. So
Is it Binash or Vinash?
Lordship, what happens is sometimes in these gargoyles, the name, they write a different name. Epic card has a different name, some other ID has a different spelling issue. It's the same person.
The same person.
Yes, even respondent number 11 is clarified, the same person.
So, my lord, they are supposed, as per our verification, they are actual landowners.
That's all right then.
They are offering, my lord. If my lord permits, I'll file a small affidavit to this effect. Their name are in the report.
MSR only on behalf of the respondent's number.
My lord, 1 to 7.
1 to 7 has produced letters dated 5/1/2022.
My lord, that may not be correct. It will be 26 to. I may.
No, wait. 6/6/2023 and 26/6/2023, indicating the fact that the two petitioners in this petition are landowners, and only what remains is for the
My lord, may have the previous page. My lord,
for apportionment of compensation.
The subject is there. Why was there a correction of mathematical and clerical error?
And for correction of mathematical and clerical errors in connection with acquisition of such land. As it's undisputed that the petitioners before this court are the correct landowners who have not yet been paid, and the payment is
they're entitled, my lord.
Is pending due to the corrections that have to be done. The learned G is directed to bring the same on record by affidavit. We'll dispose of next date with directions. Whatever mathematical or clerical errors they correct within and pay your due compensation. Or forget affidavit, we can dispose it off.
Should we dispose it off if we are aggrieved?
We can, my lord. I have no objection to that. Their name, I'm submitting that their names are there, my lord, in the list of the landowners who are entitled for compensation.
Lordship, I pray if you may kindly take up this matter after a week because learned DSGI is indisposed.
File affidavit, otherwise we'll dispose it off. No, it's clearly there that that Binash and Binash is the same VA and BI, whatever.
VI, somewhere is VI.
13.
Highly obliged, Lordship.
13.
Yes.
Please, Your Lordship. Your Lordship, the service report on respondent number 3 has been served, Your Lordship.
Received.
Quite yes, Your Lordship. Your Lordship, I pray for 2 weeks for the times, Your Lordship, to file a rejoinder affidavit.
Obtain status.
No, to file a rejoinders affidavit.
MS Bisun prays that she will allow 2 weeks time to file the joinder to the affidavit filed by respondent 1 and 2. She's been served, see. She's been served.
Yes, Your Lordship.
None appears respondent number 3. No. You not received status report.
This was service.
It's for a joint.
Can you find it, please? You have not given me a copy?
Oh, if I have a service.
Yes, I filed, Your Lordship.
Problem? See that, huh? Yes. It's further seen that affidavit indicating service has been filed on an affidavit of service has been filed indicating service for number 3, but no appearance is made on their behalf today. This is matter after
2 weeks.
3 for joinder and for appearance of number 3. Yes.
And 14.
Lordship, affidavit on behalf of respondent 1 to 4 is filed.
Filed.
Yes, Lordship.
Private respondent are yet to file their affidavit. Lordship, she had come, Lordship. The daughter-in-law, respondent number 5 had come, Lordship. We have got instructions, Lordship. I am praying 1 week's time, Lordship. We have the affidavit filed.
Any urgency?
No, sir.
Yes, Mr. S. Chanda. Please further 1 week's time to file active number 5. Just thereafter for further orders, yes.
Highly obliged, Lordship.
15.
Please, Your Lordship. My Lord, we have filed a rejoinder affidavit to the counter filed by respondent 1 and 2.
State
Yes.
respondents, they have not yet filed the affidavit if they are
There
not.
is no relief paid against us. It's against NHIDCL.
Then
What have you said in your
Your
affidavit?
Lordship, in our affidavit, we have taken the step that we are not responsible for making any payment, Your Lordship, straight away to the petitioners. Because
Who will do assessment?
Assessment-
Actually, MS Kolni, in
It
such
will be done by
matters,
the
in such
Deputy
matters,
Commissioner.
is the EDC revenue who should go and do an assessment whether there is any damage as alleged.
We have written to MIG, my lord, for the assessment.
Who's MIG?
My lord,
Meghalaya Institute of Governance.
my lord, there is a respondent here, my lord. There is one letter which we have received in our instruction, in which we have sent the concerned department to do the assessment, my lord.
You file an affidavit. Otherwise, we'll issue orders because in such matters, if these people have been deprived of their cultivation,
My lord.
the other orders been passed by this court also, with regard to highway construction and when the lands are spoiled. By this court only some regarding
Yes, my lord.
What
we-
is-
We have one letter, my lord, in which we have sent to MIG for social impact assessment report on the entire issue. my
social
lord.
impact assessment reports totally different from
That is
from
what we have
from a
been
EDC
handed over.
report, a physical report with regard to construction and destruction.
My lord, that is what we have been instructed by the department.
MSR Kolni, on behalf of Respondent 3 to 11, submits that they are still awaiting instructions. But however, it is still awaiting of full instructions. But as on date, she has only been informed that the state respondents have asked for a social impact assessment to be conducted
I'll file
by
an
the.
affidavit, my lord. It seems that as
You
per my
file
instruction,
affidavit.
inspection
Otherwise-
has already been conducted, my lord, and we have forwarded to NHIDCL, my lord, for the payment, my lord.
Fine.
I'll file an affidavit. We have already done the inspection, my lord.
No, forget. Please be allowed to file an affidavit. So, first you said you don't need to file an
My
affidavit.
lord, no, my lord, here inspection
We'll
was
bind
done,
the
my lord.
state. You can't let poor
My lord,
cultivators be
we'll
deprived
file
of the
this
thing.
affidavit. This inspection report I'll place on record, my lord.
Thomas? Praise for? Yes. List after 2 weeks.
16.
My lord, here also the issue is similar only, my lord. Road widening project and the cultivation land of the petitioner were.
You see, where's Mr. Sunar? It's an absolute liability and strict liability, in the Indian context.
Lordship,
In such projects, the cause of strict liability and absolute liability of the respondents.
No.
Yes, none.
Lordship,
You
I'm
file
appearing on behalf of respondents 7 to 8, Lordship. I'm praying for further 3 weeks' time, Lordship, to file affidavit.
What about
1 to
state
6, my lord. I'll also file affidavit in this.
MS Arkolni 1 to 6 and Ibratan for 7 and 8? They followed for the 2 weeks' time for affidavit. There's that afternoon also.
17.
Highly obliged, Lordship.
Yes.
May I please, Your Lordship? Your Lordship, I humbly pray 2 weeks' time, Your Lordship, to file
How
the
much time?
affidavits. 2 weeks' time, Your Lordship, because we haven't received a provised comment also, Your Lordship.
What's the matter about
No, actually, this is just regarding the payment of the dues, Lordship. That order is very clear. The earlier order, page 14, my lord.
Let them get instructions then.
Yes, Your
This is only for pay.
And Rajiv pays for the 2 weeks' time to obtain instructions and file affidavit. This is afternoon also.
Second call.
5 minutes. I'll come back. Okay.
Supplementary.
Supplementary? Oh, that matter.
We are again before your
What is this?
with the MRI machine matter. What has happened is, Malad, your lordships have disposed of the matter by judgment and order dated 25/20/24, setting aside the work order. Now,
Yes,
what has
I
happened is
recall.
thereafter, if I may very quickly take your lordships to page 112.
1-1? 1-1?
112.
Yes. Yes.
Malad, have it. In pursuance of the judgment and order of the Honorable High Court of Meghalaya, Shillong, in so-and-so, date of decision so-and-so, and as per the resolutions of the minutes of the meeting of the Tender Committee and Technical Committee of so-and-so, held on 6/6/2024, the tender number so-and-so, dated so-and-so, 3rd October 2023, and the work order for supply installation of so-and-so, by letter number so-and-so, dated the 9th of March 2024, stands cancelled. Your lordships had already set aside that particular order. Thereafter, my lords, they say it is cancelled. Till here, my lords, it's still okay. Your lordships will kindly look at the next line. New tender will be floated as soon as possible in this matter. Now, this, my lords, is in the teeth of the observations made by my lord at page 30. If I may quickly take your lordships to page 30, my lords.
There's an appeal also. What happened to the appeal?
My lords, in the meantime, my lords, the interesting part is, in the meantime, the state has gone on appeal. The private respondent naturally has gone on appeal. While the state is in appeal, my lords, where respondent number 2, who has now issued this letter, is a pro forma respondent, has issued this order. So essentially, my lords, what is happening is, in one breath they are blowing hot, and one breath they are blowing cold. We don't know what is the position. And I may just take your lordships to para 19 and 20, my lords.
Page?
Page 30.
Yes.
Accordingly, the award of the contract for supply and installation of so-and-so in favor of the respondent number 6 is quashed and set aside. And also the consequential order, work order dated 9/3/2024. So this order has been set aside by my lords. This court, in setting aside the award of the contract, is not oblivious to the fact that an MRI machine once installed in Tura will be a boon to the populace of the several districts in Garo Hills, and any further unaccounted delay will severely impact the healthcare situation.
Yeah.
As such, it is also directed that the concerned respondents take immediate steps to ensure the MRI machine is installed at the Tura Civil Hospital at the earliest through a transparent and fair process. My lords had never said, because the tender process was never under challenge before your lordships, my lords. My lords restricted, my lords, only to the extent of issuance of the work order. Against that, my lords, the state is in appeal before the division bench. And in the meantime, my lords, somebody who has not even issued the notice of tender decides to cancel the tender itself. If I may quickly take your lordships, my lord, who had issued the tender at page 35, if your lordships can have a look. I'm sorry, my lords, at page 23.
Of the writ petition?
My lords, of this writ petition that's quoted in my lord's order. Paragraph 11, my lords, down below, your lordships have quoted from the NIT. Well, as the Hospital Management Society, Tura Civil Hospital, I'm sorry, my lords, it's not this. Just a second. Sorry. Para 11. Well, it's the NIT was issued on 3/10/2023 by the Hospital Management Society, Tura Civil Hospital.
Yes.
Who was the main contesting respondent before your lordships? Your lordships would recollect, my lords, there was this tender committee's meeting, then the chairman sat over it.
Yes.
And your lordships have taken a view, and that work order has been set aside. Now, R2, my lords, who is the secretary, who has nothing to do with this, while R1, 2, and the rest of the respondents are in appeal before the division bench, has issued this order.
R2 is?
He's the superintendent, my lords.
What happened to the appeal?
Well, the appeal has not been listed. It's not been listed.
It's not been listed. When is it filed?
Appeal was listed, my lord. Appeal was listed.
And what happened?
No. Appeal was listed, my lords. There was some.
On 18th June, my lord. Hearing was page 1111, my lord.
18 June is day before.
What happened, my lords, is the appeal was filed by the state. There was some difficulty of my learned friend, my lords, to appear on that day. On his personal ground, my lords, the matter was adjourned. Was to be directed to be listed on the 18th, never listed on the 18th. So we are awaiting listing of that matter.
No, I mean, it's not been withdrawn.
No, it's not been.
It's a pending
It's pending.
consideration.
Both the appeals are pending.
Then,
Both appeals are pending.
then Mr. What will happen then?
Milord, kindly see what is his prayer, Milord. Kindly see what he says. I don't
No, I'm just, the courts are trying to understand what will be the, the impact of a fresh writ petition on pending writ appeals, awaiting orders or
Milord, that
admission.
is what.
No, my lords, if my learned
how
friend
this
makes a
is
statement, my lords, that they're
going
pressing the appeal, matter ends.
Exactly.
Because in one hand, my lords, I have an appeal to deal with.
You can't, yes.
In one hand, I have an appeal to deal with. In another hand, some letters coming on the background.
Yes.
Milord, kindly see what is his case. His case, Milord, he says that it should not have been cancelled. What and why it should not have been cancelled? Paragraph 11, page 8, Milord. Kindly see page 8. Paragraph. This is a proxy litigation, Milord.
Okay.
No, my lords,
Proxy litigation.
In terms thereof,
if my lords just permit me a second, my lords.
Direction passed by this honourable court dated so and so. I put a question to myself, Milord. Where is the direction by this honourable court, Milord?
Yes.
Kindly see your lordship's order. Page 30.
Before we get into that.
Listen, Mr. Archivist General, before we get into the brass tacks, now, the court just wants to know what's the status of appeal, whether it will be pursued or what will
Appeals are
happen.
pending, Milord.
Will it be
Appeals are
pursued?
pending. Appeals are pending.
It will be pursued.
It will be pursued, Milord. Appeals,
But parallelly now, you're taking with the entire cause of action. If you say that you're
No, Milord,
already issued
so far as this
notice.
cause of action, may I submit, Milord? So far as this, what is the cause of action for the petitioner, Milord? I put a question to myself.
Before my learned friend,
He wanted, Milord, the tender not to be allotted to the private party. That he has got, he did not pray for any direction to allot him the tender to him, Milord. And your lordship has passed the order. Now, what is the cause of action in his favor for cancellation? Cancellation is rather in his favor. The lordship has directed follow the transparent method.
My lords have never said, my lords, you go for a fresh tender. Before I get into this little rant, my lords, with my friend, if I may just ask myself a question, my lords, because here what is happening is...
We both asking yourself questions, you will answer yourselves also.
No, but this is like that.
You asking yourself a question, you asking himself a question. See, answer yourselves. Court doesn't have anything to do with it then.
Well, it's the only issue is here, if I may, before we get into the merits of the matter, if my learned friend is representing the state where they're pursuing an appeal, my lords, and somebody here in the middle has issued some kind of an order which takes away the substance of this entire matter. Now, whether, my lords, there would not be any conflict of interest insofar as representing both of them is concerned. That's the first question I ask myself.
Okay, fair enough, yes. Then?
So, my lords, if my learned friend says, my lords, that they're pursuing the appeal, he cannot have any grievance with my prayer here.
Milord, now what the writ code has been converted for recording my statement, Milord. Whatever.
My lords, Advocate General, being the Advocate General of the state, has its merits and demerits.
And appeal is pending. Appeal is pending, and he wants me to make a statement
make
to
up your
London
mind on what ground you're going to argue. Listen Monday. I'll go through the matter also. Otherwise, you're not going to get anywhere. You can't pursue, at two different levels. I mean, one parallel, you take parallel action also, but you tend at the same time you're pursuing appeal. You make up your mind. You come Monday, we'll even hear an interim matter on Monday also.
Melons.
Yes, heard Mr.
Melons would record notices complete because they've been served.
Mr. K. Paul, learned counsel, so and so, issue notice. Mr. A. Kumar, learned Advocate General, is present on behalf. So and so, all the respondents.
I also raise objection as to maintainability of the writ petition of this kind of.
Of course, I mean everything will be open. You come with a clear mind, but at least you should be clear on your own. What is your course of action? That's all. So the court will know.
Writ on behalf of petitioner is not maintainable, Milord. There is no cause of action. There is no writ is not maintainable, Milord.
I'm grateful.
Item 21.
Yes. The prayer for interim orders will be taken up on that said date. Yes. You're not here in the morning, they've sought for time.
Your Lordship, actually I was there, but I was not having the idea to seek for time, so I was busy reading. But anyway, Your Lordship, today is fixed only for production of the routine and the register.
Where do you get the routine from?
From the petitioner, Your Honor.
I am not aware, madam, because I have the register at the attendance register of the teachers, my lord.
Your Honor, the color routine is of the recent year, academic year, and no name is mentioned of any
Can't make out
teacher.
anything from here, I must say, right?
Yes, Your Honor.
Can't make out anything from here. What is this acquittance?
And
Rangdikio, CRPS.
that's the register she maintained, Your Honor.
Who maintains register?
The petitioner.
But this is
Because
not
she
official
was-
register of the school.
No.
No, Your Honor, because she was asked to maintain a separate register.
No.
Is that correct?
No, my lord, that can't be correct, my lord. It's whatever they feel like submitting, they're submitting, my lord.
And the black and white routine is of last year, Your Honor, where her name is mentioned. And even till date, she is teaching, Your Honor.
Have a look.
Yes.
We're trying to help this poor lady, but if he doesn't, then we'll pass orders, you accept whatever they're giving, and
Yes,
we'll
Your
close the
Honor.
matter.
Yes, Your Honor.
Uh,
And yesterday she came to submit the thing, Your Honor, and I got to know, like, even now she's still teaching social science, health, and Kotniam. So she is still teaching, Your Honor.
Well, lord, I'll have to take instruction on this because the register that they sent me, unfortunately in a scanned copy, my lord, her name is not there. There are 3 teachers, my lord. There are 3 teachers.
Understood. Only thing is that now she's seeking to maintain that she has been teaching. She has been teaching uninterruptedly. That's all. Correct.
Yes, yeah,
That's the
and
only
that-
thing.
that's
And if not, then then we'll pass orders that you're already gonna give her whatever amount as decided by the
Yes,
committee.
yes,
You
my
accept
lord.
it.
And that is the end, my lord, because that's what we were trying.
You just have a look. Have a look at that. You can take photographs of it.
Yes. As a managing committee, also we were trying to accommodate and help her.
Yes, MS Yaosai today has produced some documents which he submits shows that the petitioner is discharging her duties in the school. Mr. Yubin is permitted to examine the same. This is the matter after 1 week, yes. And to obtain instructions.
My lord, obliged.
What is the status of the register she's produced also? That we court can't.
The register, just I got it, Your Honor, but the main thing is the routine.
You will let them have a look at it. They can take
Yes,
photographs also.
I will. Can you allow me also to produce a register? But anyway, my lord, now the
We're
thing
not
is-
going into those kind
yes,
of
my
things.
lord.
It's only that we just give her a chance.
Yes, my lord.
Because she has submitted that she has been teaching non-stop.
Yes,
I mean, like regularly.
Yes.
And that now she will of employment.
Yes.
She's overaged.
Yes.
She would not, she won't get employed. That's the only thing.
Even if, my lord, even though we dispute to that one, but still, then, my lord, we are saying that let's take it on the face value.
Yes, you
We
just
will
have a look
help
at
her.
it
This is
for
what
our
we-
satisfaction.
My lord. Obliged.
Yes. Yes, Vichana, start.
This is that matter pertaining to the
Yes.
Your Lordship, this matter could come after a week, Your Lordship, because we were informed in the morning by the...
what?
No, Your Lordship, after a week, Your Lordship, because we were informed the morning they'll be seeking time, Your Lordship. We were informed the morning.
Lordship, it seems there was some miscommunication, Lordship.
So you're trying to ambush the respondent?
No, Lordship. Yeah, Lordship, what had happened, Lordship?
No, what has not happened? She's sick. Where's Mr. Jindal?
He's indisposed, Your Lordship, because we were informed the morning, so he didn't come, Your Lordship. He had some...
Okay. On the prayer of the council for the parties, let's matter up to 1 week, yes.
Much obliged, Lordship.
We sure?
Lordship.
Otherwise...
Some miscommunication, Lordship.
Yes.
Your Lordship, we made a similar prayer, Your Lordship. It's
You
from
misled also in
from,
the
no,
map.
Your Lordship, the other respondents, Your Lordship.
Court
For
getting
respondent number
confused.
9, Your
What's the
Lordship.
problem?
Your Lordship, in the morning we were informed by the other respondent that will be seeking time. So, based on that, Your Lordships, the County Council had some urgent matters.
What about the petitioner? Petitioner is the most important. You want to do the matter today? You ready?
Yes, Your Lordship.
Lordship, it's a matter of take up to 1 week, Your Lordship.
Is it urgent?
Not urgent, but it's 2023.
What's the matter about?
Just regarding the appointment
Appointment of assistant professor, my lord.
Deficit College.
Shillong College.
After 1 week, request of parties. You see, you have to be sure. You won't take adjournment, you don't take you.
Yeah. Yes, Your Lordship. Apologies, Lordship, for that. Much obliged, Lordship.
Obliged, Lordship.
36.
Yes. Yes or no, class?
May it please your Lordship. Lordship, these two villages, Nohali and Menriang, have been in dispute regarding their boundaries.
They have been in dispute. There's always dispute.
They are always dispute, Lordship. And however, since the 29 September 2092, it was, however, to some extent settled. But then again, Lordship, the respondent 5, that is from the Menriang, the headman of Menriang, he was not satisfied with whatever has been settled. So
who number 4 and 5? 5 and 6 or 4?
Five.
I'm number 5. The other village member.
You're for Hononghali?
I'm for Hononghali, Lordship.
Yes.
And then ultimately, Lordship, once again the matter was settled. That was on the 9/12/2015 by the initiative of the pro forma respondent and all concerned, Lordship, and it was settled, Lordship. In fact, that was in page 51,
page?
Lordship.
Yes, sorry. Page
51.
51.
If I may read, Lordship.
Yes, please.
A judgment in bracket Hukum dated 9 December 2015. This issue between Nonghali and Meriang villages started since the year 1991, when both villages were under the administration of one headman, Sardar, that is the headman Sardar of Nonghali. And due to the dispute and misunderstanding among the elders of the residents of two villages, which has led to the demand of the residents of Meriang to have a separate administration in village, the residents of Nonghali insist on being together. That due to the fact that the two villages cannot be together under the same administration, the matter has gone to the Executive Committee, KHDC, in which the KHDC Wide Order dated 28/4/2000, it has directed the CM and Darbars to recognize Meriang as another village. Therefore, there has been a demand from the village Meriang to get a clear boundary that would separate Meriang from Nonghali village. Within the last 15 years, there has been an unfortunate incident in which the elders and residents of Meriang have burned the charcoal prepared by the residents of Nonghali. In this regard, the then Sardar Nonghali, late Mawel Khasati, has lodged a complaint to this Darbar White complaint has dated 6/3/2001 against the Sardar, headman of resident of Meriang village. Therefore, it has been resolved that the residents of Meriang would go to Nonghali and tender an apology for their mistake and the fault.
Where are you reading from?
I'm reading page 51, Lordship.
51 that's missing from that one. Out here, there's actually complaint against Sardar, headman of Meriang village, and next that after the Darbar becomes issue.
I think something.
One line is missing, I think.
I think so, Lordship.
From this court's copy.
Yes, Lordship. I'm very sorry. It's
Then?
missing, Lordship.
What is that line? What's the missing line?
Missing line is that they have been Meriang residents have been directed to pay compensation for that.
Is there in this order? Let us see your copy.
In this order, Even my copy is missing, Lordship. That page is missing.
It's missing. In your copy also?
Yes, Lordship.
Missing, Lordship.
Mr.
I think it's missing.
Nongri, is it there in your copy? They allowed you to pay compensation?
Compensation part is not here, but at page.
Then where's reading? Where's Ms. Nokha reading from?
In page 50, Lordship, if you come to page 54, Lordship, next
the
page.
Problem with the pagination, Malad.
Yes,
From
Lordship.
51 it goes
54.
straight away to 54.
That is the next page, Lordship. It's mistake in page.
I think we have to correct. Make a correction.
Lordship, in that case, I may be allowed to correct.
Yes, you kindly corrected, Mr. Nokha. Please allow to correct the pagination. You rearrange the pages.
Lordship.
Rearrange the page repetition as there appears to be some errors in the pagination. Stop praise allowed.
Sorry,
after?
After 2 weeks, Lordship.
You should do it. You should have checked the copies before filing.
37.
Lordship, the interim order may continue, Lordship.
Interim order is only until the end of the, since only in hearing. Yes.
Please, Your Lordship, let this matter come after 2 weeks.
Why?
The school managing committee is yet to enter appearance.
No, they've already been served, correct?
Already been served,
Where's
Lordship.
Mr. Hassan? Who's there?
Yes.
Who's
Already been
appearing?
served.
She's not ready. She's been
But they-
deserted by her.
But they could have
colleagues.
informed us, Lordship. This is the last matter we were waiting for this only.
Last hour, isn't it? It's only 12:30.
Basic decorum.
If it's 5 o'clock, yes. At least after 2 weeks, yes. As prayed by the council petitioner.